But first, from Fox at 3 o'clock in New York City, the Fed's keeping tabs on another journalist. And this one happens to hit close to home because the targeted journalist is Fox News chief Washington correspondent James Rosen. Fox News has just obtained the search warrant. We've now learned that the Justice Department tracked James Rosen's movements at the State Department and seized 2 days worth of his personal emails, not Fox emails, his personal emails, while looking into the possibility of leaks of classified information about North Korea's nuclear program. And those personal emails may provide a major twist in the story. Here's why.
The Justice Department went to a judge to get a subpoena for that, and the subpoena was issued, according to the story, because the Justice Department was alleging that the reporter in question, our colleague James, had engaged possibly in a conspiracy, a criminal conspiracy.
A criminal conspiracy. Fox News Executive Vice President for News, Michael Clementi, issued this statement today. We are outraged to learn today that James Rosen was named a criminal co-conspirator for simply doing his job as a reporter. In fact, it is downright chilling. We will unequivocally defend his right to operate as a member of what up until now has always been a free press. Shannon Bream with the news, live in D.C. Shannon?
Well, Shepard, what's key in these new revelations about the Justice Department and FBI investigation into our colleague James Rosen is that the FBI agent who filed the affidavit in this case in support of that search warrant that would allow authorities to access Rosen's personal email account said, in his opinion, that Rosen had committed a crime by allegedly working to obtain information from a source at the State Department. In an affidavit by FBI agent Reginald Reyes, the agent writes that he believed the evidence in the case showed Rosen had broken the law, quote, at the very least, either as an aider, abettor, and or co-conspirator.
It's a very dangerous claim. And the notion of pinning the label of criminal on the press because it gathers news from someone who may not have the authority to provide the news is extremely dangerous.
Rosen was never contacted by the government despite an in-depth investigation which, according to the Washington Post, included obtaining that search warrant not only for his personal email account, but also tracking his movements by examining the use of his security badge at the State Department. Also out today, a report by the Inspector General at the Justice Department investigating a potential leak to the media regarding Fast and Furious, the controversial gun-walking operation. The report mentions 2 Fox employees, reporter William LaJeunesse and producer Mike Levine, and quotes from their emails. But DOJ officials tell us they did not subpoena any reporters' records or emails in that particular investigation. Shep.
Shannon Bream live in Washington. Shannon, thanks very much. Let's take this to the judge. Fox News senior judicial analyst Judge Andrew Napolitano. Judge, hello.
Shep.
This isn't about us. It just so happens that this time it's one of our reporters. Last time it was Associated Press. We'll see who it is next time.
Correct.
If James Rosen did every single thing that the Department of Justice listed in the subpoena, where's the crime?
There is simply no crime. And it was terribly wrong for the FBI to tell a federal judge. The FBI submitted a half-page thick affidavit. Here's a copy of it to a federal judge, which is the way you do it. You summarize the reason for which you want a search warrant. And then you say, here's why this person behaved criminally, and here's the evidence the search warrant will uncover. For the FBI to tell a federal judge that James committed a crime by receiving classified information and offering to publish it, even by asking for classified information, is absolutely wrong and brings the Justice Department into an entirely new area of invasion of First Amendment privileges. James, like all of us who are professionals in this business, have an absolute constitutionally protected right to seek news of material interest to the public wherever that news may be. Now, don't get me wrong. It is a crime for someone who has a classified clearance and classified materials in their hands to give it to someone who lacks that classified clearance. It is not a crime if the person who receives it is a journalist. It is not a crime for the journalist to receive it. It is not a crime for the journalist to ask for it. It is not a crime for the journalist to publish it. And it is just terribly wrong to tell a federal judge that that journalist engaged in criminal activity when we know from Supreme Court opinions from the Pentagon Papers to the present, James's activity is absolutely protected by the First Amendment.
And when they do issue this sort of subpoena, by law, they have to tell you they've done it. Don't they?
Yes.
I mean, they went into our computer servers at Fox News, went around our security, pulled things out, and didn't tell us they'd done so.
And Fox found out about it, and James found out about it from a report in the Washington Post this morning. Shep, this happened 2 years ago. This is dated May 28th, 2010. The government has an obligation to report this to the target, James, and to anybody else involved, Fox, the computer server, whoever else might be involved, within a reasonable period of time. In fact, depending upon what statute the government relied on, when the information is in the hands of a third party, like a computer server, they have an obligation to tell you beforehand so you can challenge this. They didn't tell anybody.
I read the word chilling a lot today. It's in the statement that's put out by one of our executives. That's actually a word from the Supreme Court.
Yes, it is. The Supreme Court has ruled that when the government makes it difficult for you to do your job as a journalist by scaring off your sources or watching your every move, that's called chilling. Chilling is a constitutional phrase meaning the government hasn't directly silenced me, but it's made it more difficult for me to speak.
Judge, thanks. Hang on a moment. The IRS controversy now as new details emerge over who knew about the agents targeting conservative groups for extra scrutiny before the election in 2012. We've now obtained a letter which the IRS watchdog sent in July of last year to the chairman of the House Oversight Committee, the California Republican Darrell Issa. That letter essentially gave Chairman Issa a heads up that an investigation was underway into how the IRS conducted oversight into organizations requesting tax-exempt status. Now remember, the White House also revealed that its top attorney knew several weeks ago that the investigation was nearly complete. The White House stressed that President Obama did not know about this controversy until very recently, but some top Republicans are arguing maybe the president should have known.
For me to believe that the IRS commissioner knew about this a year ago and didn't tell anybody, it's hard for me to believe that the White House counsel knew about this a month ago and didn't tell the chief of staff. If that's the case, you don't have much of a counsel.
It is critically important that the American people have trust that the IRS, which is involved, has a very intimate relationship with people and their finances. It's critical that they know that it's being done in a nonpartisan way. And so this was a breach of the trust, regardless of the motivation, regardless of how it happened. It was a breach of the trust, so we have to fix it.
Well, it appears that President Obama's second-term agenda has run into even more roadblocks. Mike Emanuel's on Capitol Hill. Mike, and the White House just revealed more. What do we learn now?
Well, Shep, at the start of a busy week here on Capitol Hill, the White House is fleshing out the timeline about what was known when about IRS targeting.
We knew the subject of the investigation, and we knew the nature of some of the potential findings, but we did not have a copy of the draft report. We did not know the details, the scope, or the motivation surrounding the misconduct, and we did not know who was responsible.
Carney went on to say at that point the report was not final and was subject to change. Now, as soon as tomorrow, there will be more congressional hearings about the IRS matter. In the Senate Finance Committee, they will feature three key figures: outgoing acting IRS Commissioner Steve Miller, Inspector General J. Russell George, who did the report on the IRS targeting, and Douglas Shulman, former IRS Commissioner. So you can expect plenty more tough questions tomorrow, Shep.
What can we expect from these next hearings this week on the IRS?
Well, Darrell Issa, the chairman of the House Oversight Committee, who is chairing a hearing himself on Wednesday up here, had this to say, quote, exactly who in the administration knew about the IRS targeting is one of the key outstanding questions. In waiting so long to address wrongdoing and inform the public, President Obama and his administration seem more preoccupied with having deniability than quickly addressing serious wrongdoing. Meanwhile, a leading Senate Republican is calling on his colleagues to have patience.
It's hard to do when you're outraged, but the right thing to do here is let the facts come out. Don't try to prejudge what they are. It's more and more obvious to me that we're going to find out that more people knew about the IRS than have admitted so far they knew about it, and people are going to be upset when that happens.
With the IRS, Benghazi, and the Department of Justice targeting reporters, these controversies threaten President Obama's second-term agenda, even though his aides say they're going to try to move forward with what they had planned. Shep?
Back to the judge. Mike, thanks. Fox News senior judicial analyst Judge Andrew Napolitano. They didn't know anything. The reason this matters, obviously, is because if they knew, the question would be, well, did you direct any of this? If so, were you working on politics from inside the White House? You can't do that.
Well, exactly. I mean, the allegations now are that the IRS was doing this for more than a year. What was happening a year ago? The president was running for re-election. So did people in the White House know that the IRS was applying additional scrutiny to the tax documents of conservative groups, perhaps to keep them at bay during the election? If that's the case, you could argue this was a political decision. If none of the political people in the White House knew about it, then the IRS will say, well, we did this because it was overload. We're getting too many of these applications. You can make both arguments. But the Congress needs to get to the bottom of it, because who knew what when is of paramount importance.
Investigating 501c4s makes sense, because what they do is they have to spend half or a little bit more than half of all of their money on certain matters, and then the rest of it they can just spend on political operative business. That's because of this ruling from the Supreme Court. Whether you like that or not doesn't really matter, but you have to investigate whether they're at the right threshold, whether they're dodging tax laws. That makes sense, but to apply to one side and not apply to the other, that doesn't make sense.
That's the constitutional issue. When the government makes a decision about how to treat a taxpayer based on the taxpayer's speech and political views, same as we talked about before, that chills the speech. That punishes you because of your speech. It treats people in a similar situation differently rather than similarly, as the Equal Protection Clause of the Constitution and the First Amendment require. So again, this is just the beginning of what needs to be known here in order to resolve this.
Judge Napolitano, thank you.
You're welcome.